Do you feel safe in your home? Sadly, the answer is no for thousands of West Australians affected by family and domestic violence, FDV for short. Private or social housing tenants experiencing family violence have found themselves trapped in lease agreements because leaving at short notice means they'll owe the landlord money, can be taken to court and might not get their bond back. In 2019, WA tenancy laws are changing to remove these barriers. Tenants facing family violence will be able to stay or go without legal or financial consequences of breaking lease. Family is a broad term including two people who are or used to be married or de facto, intimate partners, children and parents, other relatives or personal connections such as carers and dependents. Violence is controlling an adult or child through fear and can be physical, emotional or psychological. Behaviours include assault, sexual abuse, stalking, restricting freedom, threats, isolating a person by preventing access to money, friends, family or culture, damaging property, hurting or killing pets. A tenant choosing to leave a rental home for family violence reasons needs to provide a termination notice to whoever they rent from, plus evidence such as a family violence restraining order, proof of criminal charges laid or an upcoming court hearing, or a new official consumer protection form to prove the reason for leaving is FDV. The Consumer Protection FDV evidence form for tenants is the first of its kind in Australia and based on a model proven to work in Canada. The form needs to be signed by a specific qualified professional who knows the tenant to be a victim of family violence, such as a doctor, police officer or person in charge of a women's refuge. A tenant who provides a termination notice and FDV evidence to their landlord can give 7 days' notice and leave the rental home any time that week. A perpetrator of family violence does not have to be named on the lease for a tenant to use this termination notice. The landlord must give anyone else listed on the lease as co-tenant a copy of the termination notice only, not the FDV evidence form, which is confidential. If any co-tenant wants to stay and can afford to, the landlord must let the lease continue. Or a co-tenant can choose to leave with 21 days' notice. If a tenant affected by FDV wants to stay in a rental home, perhaps because they have children who attend nearby schools, they can apply to the court to have the family violence perpetrator's name removed from the tenancy agreement. A landlord and any co-tenants will find out about this hearing via a notice from the court. Under the tenancy law changes, the court can assign liability for damages or debt related to FDV to whoever's responsible for the family violence. It doesn't change how much a landlord can claim, just the person who pays. Tenants can change locks without permission to prevent family violence. For private rental homes, the landlord must be given a copy of the key within 7 days. Lock changes are at the tenant's own cost, but there are some schemes to help fund lock changes for safety reasons. Security upgrades can be made without permission as long as the tenant tells the landlord beforehand that they intend to make the security upgrades. They're done by a qualified tradesperson, the tenant or a funding assistance scheme pays, and a copy of the invoice is given to the landlord. At the end of a tenancy, a landlord can ask for property to be restored to its original condition through removal of security upgrades. Offering tenants affected by family violence all of these new options may reduce damage to rental homes and mean less abandonments, which can involve time-consuming processes for landlords to dispose of goods left behind or to chase up unpaid rent. But most importantly, these changes have the potential to save lives. If you want to use the new laws to leave a tenancy for family violence reasons, contact Consumer Protection or your local community legal service for help.